You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't. Hi, Chad Franzen here, one of the hosts of Share Your Voice, where we talk with top-notch law firms and lawyers about what it takes to grow a successful law practice. This episode is brought to you by Gladiator Law Marketing, delivering tailor-made services to help you accomplish your objectives and maximize your growth potential. To have a successful marketing campaign and make sure you're getting the best ROI, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. Rick Williams is a trial lawyer and mediator who has been practicing in Northern California since 1975. He has run his own practice, been a senior partner at a large multi-state litigation firm, and currently is a partner and manages the office of Gray Duffy LLP in Redwood City, California. After 48 years of trying a wide variety of cases, from medical malpractice, personal injury, employment, class actions in business, and contract disputes, he currently devotes his time to acting as a mediator, resolving cases for parties and their counsel through the collaborative negotiation process of mediation. He has successfully mediated and arbitrated in excess of 1,000 cases over the past 15 years. Rick, thanks so much for joining me today. How are you?
I'm doing very well, Chad. Thanks for having me. I appreciate it.
Hey, as I read in your intro, there's a lot we could unpack and talk about, but why don't we start by, if you could just tell me a little bit about what Gray Duffy does and kind of specializes in.
Okay. Gray Duffy is a small boutique firm with two offices, one in Woodland Hills, Southern California, and the office here in Redwood City that I am part of and that I run. We handle all types of litigation, from injury and insurance litigation to plaintiff injury and plaintiff business work. I would call us a small boutique trial firm with a lot of lawyers like me that have a lot of experience that have earned a little gray hair and have been in practice for a while. We enjoy a good broad spectrum practice from the business side to the insurance side to the injury side.
How and when did you know that you wanted to be an attorney?
I graduated from college not knowing, like most young people when they graduate from college, what direction I was going to take and what I was going to do. And at that time, I had an older brother, still have an older brother, who was just graduating from law school. And I was motivated by that. Obviously, there's competition between brothers, and you know, I had friends that were lawyers. My father had been in the Navy in World War II and had been accepted to law school, to Harvard Law School, actually. And then when he got out of the Navy, he found himself with two little kids and no money, so he never went to law school. So he encouraged me, along with an older brother who was already a member of the bar, to give it a shot. So I did. It wasn't something I dreamt about since I was a kid, but it was something that just kind of looked like it'd be better than teaching history, which is what I was a major in, and I'm still a history buff. But it just kind of happened. Let's put it that way. It was sort of a natural progression.
Sure. What have you? What was, if you can think of it, what was most attractive about being an attorney at the time? About potentially being an attorney at the time, and what have you most enjoyed about it? In the 40 plus years since.
At the time, I really didn't know, because I really didn't know much about it. It has a glamorous reputation, obviously, like medicine or engineering. I mean, it has a reputation for certain things. I think what I thought I'd like about it, and it turns out I have liked about it, is the fact that you're dealing with people, and you're dealing with people's problems, and you're trying to help people resolve problems, regardless of what side of the dispute you're on. It's a people-oriented profession, and I'm a people person, always have been. I like to try and help people. like to try and resolve disputes, which is why I do mediations now in part. And so I think that's what I was looking for going in, and it hasn't disappointed me over the almost 48 years I've been practicing. It's still all about people. And every time I get a new mediation or a new case, it's new people, it's new facts, and I find that exhilarating. I find it keeps my interest up and it keeps me motivated.
What was your first job in the legal industry?
My first job in the legal industry was after my second year of law school. I got a job as a law clerk with a boutique firm, a lot like the firm I'm with now, up in Sacramento, where I was going to law school, with a medical malpractice defense firm that was defending doctors and hospitals in malpractice claims. And I spent almost 3 years with that firm as a law clerk. And the gentleman whose firm it was really was like a coach and a mentor to me. And actually, I sat second chair with him in about 6 trials before I even graduated from law school. And so it was a fabulous job and a fabulous training experience. And that was my entree into the law, and probably why I became a trial lawyer in the first place, because I'd been exposed to it as a law student.
And you, at what point, had your own practice? Tell me about that and how that came about.
Um, I came back to the Bay Area after 4 years in Sacramento, and started working for a small insurance defense firm on the San Francisco Peninsula. Worked there for 4 years, getting my feet wet, trying cases and learning the business. And in it would have been 1980, 1979, 1980, I left that small firm and started my own practice down in San Jose, California. And after having 3 kids, I decided that it might be a good idea to have some partners in a little bit larger organization than my own shop. So I ended up joining a firm that I was with for almost 30 years, uh, so that I could raise my family and enjoy some partnership with other lawyers who were similarly situated.
Yeah, sounds good. So you were a trial attorney for a long time. What would you say? Is there Would you say that being a trial attorney is kind of an exact science, or is it more of an art?
No, it's the latter. I mean, there is a little bit of science to it. I mean, you got to follow the rules of evidence, and there are certain things that you need to do. But it's really an art. It's a skill that you develop over time. Uh, Presenting a case to a judge or a jury is really an art that it takes a long time to perfect. It's a very subtle thing, I think. I mean, you can take courses, and you do take courses in law school and after you get out of law school in different trial techniques or practices, but it's really about learning how to present yourself to a jury or to a judge in the best way to represent your client. And that's something that just evolves as you mature in the practice.
Is that presentation different depending? Like, would you go into the presentation different if it was just before a judge or if it was trying to connect with a jury?
Yes, absolutely. Judges are lawyers. And so most judges, they have the similar training to what you have as a lawyer, and they think probably more like you do as a lawyer. So you can tailor your presentation to someone who knows the law, knows the rules of evidence, and you can streamline it more and focus it more to a judge. In front of a jury, you have to keep people interested. You have to hopefully convince them to believe your client and you, and like your client and you. And that's a completely different undertaking than standing in front of a judge who's sitting there with a robe on. Um, it's a lot more fun to try a case in front of a jury. And in many ways, it's a lot more challenging because there are so many variables, because you're dealing with 12 people and usually some alternates. who don't know you, don't know the law, don't know your client, don't know anything about your firm or what you've done in the past, whereas a judge probably will have some history about you or your firm or your client. And so there's not as much of a learning curve with the judge as there is with the jury. So it's a very different dynamic, very different dynamic.
Do you have to worry about what the potential jurists might think of you during jury selection?
Oh yeah, absolutely. Jury selection, as I'm sure most lawyers would tell you, is one of the, if not the most important parts of a jury trial. And you want to educate the jurors on what your case is about, at the same time trying to find out if they're willing to listen and willing to be open-minded and willing to be fair, and if they have prejudices that might affect their judgment, what they are, and can you identify them and figure out a way to either get them to acknowledge it or convince the court that they're not right for the jury panel in your particular case. And as you know, you have a certain amount of challenges you can use. You want to try not to use those challenges if you don't have to. But it's a very interesting experience picking a jury, and I think it along with the closing argument are the two most important parts of most jury trials.
What would you say? I'm sure in law school you learn all about the law and you learn how to formulate an argument and all those things. But in terms of the ability to connect with a jury, like what would you say to a new lawyer is the key to being able to do that? Is it to be yourself? Is it to appear as honest as possible? I mean, be as honest as possible. Or what do you think?
Well, all the treatises that you read and all the textbooks that you read say you have to be yourself, and that's absolutely true. If you try and put on airs or be something you're not, people are going to see it right away. And so you're going to start with, behind the eight ball already. Uh, you just have to, one, you have to believe in your client and your case. Because if you don't, you're never going to convince 12 people to believe in your client or your case. And two, you have to be honest with the jury. You have to acknowledge the weaknesses of your case, and every case has weaknesses or failures. You have to acknowledge those and deal with them. And you have to, I think, try and come across as honestly and directly and as, what's the best word? As quickly and as expeditiously within the time constraints as possible. You don't want to bore people. A lot of people get stuck serving on juries and they don't want to be there. So the easiest way for them not to like you is if you waste their time. They already don't want to be there, and now you're wasting time with a lot of fluff that isn't necessary. So I think a straightforward, honest, direct presentation is always the best way to go. Always.
How long have you been with Gray Duffy now?
Let's see, 13 and a half, 14 years.
So you have been you're doing mediation now. Tell me about how your practice has kind of evolved from, being a trial lawyer to a mediator.
Um, Mediation really started to become popular in part of the system of resolving litigation, 25 years ago, maybe 30 years ago, late 80s, early 90s, mid 90s. By that time, I had gotten a lot of trial experience, and I would sit as a judge pro tem for the superior courts, handling settlement conferences for them, which a lot of judges do. Most courts have systems where they bring in experienced lawyers to hear settlement conferences to help the judges out because they're understaffed. The courts are. I started to get calls from other lawyers saying, "Hey, I've got this case. Would you mind seeing if we'd like to hire you to try and be the settlement conference judge privately to see if you can resolve this case?" And I did that, a few dozen times over a several year period. And I decided, and I watched how the alternate dispute or ADR practice, alternate dispute resolution practice, as it's called, was evolving and starting to grow. And I thought, this is something I think I'd like to do. I'm relatively good at it. I've got a reputation. People know me. They know I'm a fair-minded guy. They've been against me or with me in cases on whatever side they were on. And it just kind of evolved, and I started doing more of it. And I talked to some very close friends of mine who were retired judges who were working for some of the big mediation arbitration outfits, and they recommended I get some training. I went down to Pepperdine Law School in Southern California, where they have a fabulous program where most of the big ADR outfits send their retired judges and the lawyers that they hire to get training. Anyway, I went down and got training, and I just started, getting the word out there that I was going to try and transition into this. And it took 5, 6, 7, 8 years of continuing to practice and continuing to handle mediations to get a mediation practice going. And it just kind of evolved. As I aged and as my practice grew, it just became something that I decided I wanted to do basically full time.
What are some elements of the mediation process, maybe from a practical or a philosophical standpoint, that help it streamline the litigation process and make it more humane?
Humane is a good word. Litigation is a tough, rigorous, ugly business, especially for the parties involved. Um, Most disputes settle ultimately, as you probably know. Most of them settle either on the courthouse steps or during the course of the trial, or before the trial at a settlement conference or a mediation. Um, Mediation is voluntary, which is a very important thing. If you have parties that are willing to sit down and talk, you can usually forge a resolution of some kind. So I think trying to get your handle or your arms around the emotion involved in the litigation, and there's always emotion, regardless of the type of dispute, whether it's business or personal, there's always emotion. Those are the big things. Making it a humane process, to use your word, is the biggest and most important part of the process, in my opinion, along with confidentiality, which is very important for obvious reasons to all sides of a dispute. And mediation is voluntary, it's completely confidential. If a case doesn't resolve in mediation, nothing said or done or produced during the mediation can be used in the ultimate trial if it has to go to trial. So you get this compact process that allows you to bring all the sides together in an informal setting, in a confidential informal setting. And it's a very productive methodology of resolving disputes. And it's gotten to be more so as it's become more popular, because a lot of folks like me that have strong litigation backgrounds have gotten into it. And we take the skills and the knowledge we've picked up over the years and we throw it into this process, and it works. I probably settle 95% of the cases that I mediate during the mediation. Sometimes there's follow-up required to get the details done, but it works. The process works, and it's much better for society as a whole, because judges don't get tied up in civil trials that can go on for months, and they can attend to the other business of the courts, which unfortunately in today's world is primarily criminal matters. So I think it's a very necessary adjunct to the overall judicial process.
As I mentioned in your introduction, you have successfully mediated and arbitrated more than 1,000 cases over the last 15 years. How would you describe your success rate in terms of handling these or mediating these difficult cases?
Uh, it's funny. Some of the simplest cases, like a fender bender personal injury case, can be the most difficult to resolve. And some of the most complex cases, technology cases or employment cases where there's a lot of emotion, or a very serious injury or wrongful death case, can be the easier cases to resolve. But I would say, as I think I alluded to a moment ago, I probably settle between 90 and 95% of the cases that I mediate if not during the first session. And most of my cases only go one session. I try not to waste a lot of time. I try not to tell too many war stories, especially with people that have used me before. They've heard them already. um, and, if a case doesn't settle, I don't let it go. I follow up. I contact the lawyers by phone, by email, whatever, and, continue to push and prod and poke and until I get it settled. I would say overall, including cases that I have to follow up on that don't settle at the mediation session itself, I probably settle 96, 97, 98% of my cases. It's the rare one that doesn't ultimately settle. And frankly, even if the mediation process doesn't settle it, most of them settle by the time they get to the courthouse steps, because we've developed avenues during the process that the parties can use then to get the case settled.
What would be kind of like a garden variety scenario where somebody's just like, I'm not settling. They're just that confident in their case, or what would that be?
Well, one of the things you do as a mediator at the outset of the mediation is try to figure out what the interests of the parties really are. And if you have a party who is intransigent like that and is just saying, I don't care what they offer me, I'm not settling. I want to see those jerks in front of a jury and I want to put on my case. You need to learn that early on, and you need to try and educate that person or lawyer or whoever it may be, or business, as to why that is not the right approach to take, that approach is ultimately not going to be productive, and that they have to get past that. You have to figure out a way to get through that stubborn attitude or that emotion and talk to them and show them why there are good reasons why they should compromise and why compromise is a better thing for them in the long run, whether it's a better business solution or there's an emotional reason why they need to get closure, and compromise will get them there. You need to grab on to that type of an intransigent party right away and just keep massaging it and keep working it and keep, those mediations can take a long time. Sometimes they take more than one session, but you just need to keep working it. And ultimately, you have your bag full of tricks as a mediator. You keep throwing different things out there, and ultimately something sticks, so to speak. It's like a bowl of pasta. You throw it up and hopefully something will stick, and that means it's done and you get a settlement.
Are there some moments during your time as a mediator that you're particularly proud of?
Some of the most difficult cases I've mediated, besides horrible injury or wrongful death cases, have been employment-related cases or harassment or discrimination cases where there's a lot of emotion, just deep-seated injury because someone has been discriminated against or harassed or attacked. And I find it very satisfying to get cases like that resolved that are so emotional, because you can see the release in the parties involved as the mediation process unfolds. You can see what I think is a positive effect and how it's affecting those people, and where they're going to go with a settlement for the rest of their lives. I find that the cases that involve real people as opposed to corporate disputes are more satisfying, because you can see an immediate positive effect on an individual or on a family. And I find that very satisfying.
I have one more question for you, but first, tell me how people can find out more about Gray Duffy.
Well, our website is www.grayduffylaw.com. Like all firms, we have a website that'll tell you who our lawyers are and what we do, and lots of pretty pictures, like everybody has. And that's the best way to do it. They can pick up the phone and call me at our office in Redwood City, or they're in Southern California, they can call our office in Woodland Hills. And we're out there like everybody else.
If people can see your background, my last question for you: if people can see your background, they can see Stanford University. That looks like a beautiful campus. You went there and you played football there. Is there anything that you learned from your experience? That's a pretty unique experience to play Division I football. Is there anything you learned from that experience that you have carried with you throughout your career in the legal industry?
Probably perseverance and humility. I learned a lot from the education process at Stanford, which is obviously a fabulous school, like all the schools on the West Coast, at least the Pac-12 schools. We like to think like the Colorado Buffaloes, because I can see your shirt.
Oh yeah,
yeah. I was humbled by my experiences in college, and I think that experience has carried through my professional practice for the last almost half century, and I don't think I've ever gotten to the point where I'm ahead of myself, and I look back and think, hey, you're pretty cool, man. I think I've been able to maintain a sense of humility in who I am, and that I'm no different than the next guy on the street. I think that's what it did for me, quite frankly.
Yeah, well, I would think, just being a student at Stanford would be incredibly challenging. I would think to be an athlete and a student there would be, you'd have to be pretty self-disciplined at a pretty early age.
It was a unique experience. It really was. Yeah. Yeah. Like any student athlete at any institution, whether it's Stanford or any other school, you learn the discipline and you learn to respect people that do that go through what you went through or are going through what you went through. And I've tried to carry that attitude over to my professional practice. And I think that's something that we can all try and emulate, as we age and grow into our professions.
Hey, Rick, it's been great to talk to you. Thank you so much. Really appreciate your time, your insights, and sharing your stories with us. Thank you very much.
Chad, thanks a lot. I look forward to talking to you again.
Absolutely. So
Thanks
long,
for
everybody.
having me on.
Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.